when the defendant stole $17,499, he wasn't just taking a mere piker amount of money. He stole the public trust from the people of West Palm Beach.
Finally, Johnny, did you ever receive $10,000 in flash money from Rick Bradshaw on February 8th, 1991?
No.
Did you take any money out of the blue bag?
No.
Do you have any idea who did? Just yes or no?
No.
All right, Mr. Mixon, has the jury reached its verdict?
Yes, sir.
Please hand it to the bailiff.
We, the jury, find as follows.
I'm Joseph Wells, Chairman of the Association of Certified Fraud Examiners. At some point in your career, you may be involved in a fraud trial. It might even involve an employee like Johnny McKenzie.
I was responsible for internal affairs. They investigate or make inquiries about misconduct among police officers.
Johnny McKenzie was no ordinary employee. He was the Assistant Chief of Police of West Palm Beach, Florida.
McKenzie has been accused of stealing over $17,000 from 2 police funds.
How do you account for the money that's missing?
No comment.
Why did you turn yourself in this morning?
No comment.
We won't try this in the press. We'll try it in the place that is appropriate, which would be in a courtroom.
And in that courtroom, McKenzie was defended by no ordinary attorney. His lawyer, F. Lee Bailey.
Johnny McKenzie's life, his professional life, was in that witness box.
The purpose of this video, which is designed to be used with the accompanying workbook, is to familiarize you with all major phases of the fraud trial.
Other than that, we're ready to go?
Yes, Your Honor.
Okay, bring him in.
There are several pre-trial stages to any litigation, but once a case reaches the courtroom, every trial, including the fraud trial, consists of 7 basic steps. Those steps are jury selection, opening statements, the prosecution's or plaintiff's case, the defense, closing arguments, deliberations, and the judgment. The first step in the trial is jury selection, which is also known as voir dire. Jury selection is generally the same for any trial, whether it involves fraud or not. G. Michael Lawrence, Civil Counsel for the Association of Certified Fraud Examiners, discusses how jury selection works.
Usually the judge will ask the juror in the juror panels a series of questions that relate to their qualifications, first of all, and the qualifications are minimal, but you have to ask people, for instance, whether they can read and write, or other very basic questions.
Those who meet the minimum qualifications are then questioned to see if they can be impartial in the case at hand.
The judge then will ask about questions that relate to their connection with the parties. You know, if a party to the case is one of the potential jurors' best friends.
Finally, the attorneys in the case get to question the potential jurors. The lawyers weed out jurors who may be biased against their case, and of course they're looking for people who will be sympathetic to their side.
The lawyers have some limited ability to ask questions to the individual jurors. Again, they're going to be probing, asking the jurors questions to see if they have some kind of experience that would make them biased or prejudiced against one or the other parties or some position.
The jury that will decide McKenzie's fate consists of 6 persons and an alternate. In some jurisdictions, a jury will consist of 12 rather than 6 people. W. Michael Kramer, criminal counsel for the association, says a lawyer's ability to pick the right jury is a crucial element of winning.
And there are people today who believe that the jury selection is the most important part of the trial, that the selection of the jury has a far more to do with the outcome of the case than the arguments of counsel or even the evidence.
After voir dire comes opening statements, when the lawyers summarize the issues for the jury. The party with the burden of proof gives its statement first. Of all of the phases of a trial, Michael Kramer says that none is more important than the opening statement.
A significant percentage of jurors in a case make their minds up based on the opening statements. I've seen several studies recently that affect fraud cases as well as other complicated cases in which the The consultants and the sociologists have said that a number of jurors decide what side they favor at the outset, and then after that they tend to manage the evidence to comply with their preconceptions.
After the opening statements comes the case in chief, when each side calls its witnesses and presents evidence. Since the prosecution has the burden of proof, it goes first. Mackenzie has been charged with 2 counts of theft. Count 1 is for $10,000 that's disappeared from the department's investigative fund. Count 2 relates to $7,500 that's missing from his safe. Mackenzie has also been charged with 1 count of official misconduct for failing to make an entry in the department's books. The prosecutor has called Sergeant Calvin Bryant to the stand. Bryant is the officer who discovered during a routine audit that money under Mackenzie's control was missing. All witnesses are put under oath before giving their testimony.
Please state your name.
Calvin Bryant.
Witnesses are usually asked a short series of identifying questions to help introduce them to the jury.
And what is your occupation?
I'm a police officer, sergeant with the West Palm Beach Police Department.
How long have you been a police officer?
21 years.
When a witness is being questioned by the lawyer who called him to the stand, this is known as direct examination. Michael Kramer discusses the importance of direct examination in a fraud trial.
In a fraud case in particular, a well-prepared direct examination is far more important than cross-examination. In TV dramas, all the activity happens on cross-examination. The witnesses break down and change their stories and so on. But in real life, that doesn't happen. And so 99% of the evidence that the jury relies on comes in on direct examination.
Calvin Bryant is the prosecution's key witness. During his audit, Bryant asked to see the money in Mackenzie's office safe. Unfortunately, Mackenzie could not produce a $10,000 portion of the funds known as the flash roll, which is kept by police departments for use in undercover operations.
He searched the safe looking for the $10,000.
Okay. And what did he say at this point?
He did not produce the $10,000 from the safe, and along with that, he started offering explanations as to what may have happened with the $10,000.
30 minutes after this meeting, Mackenzie approached Sergeant Bryant and said he had found the missing $10,000 in his file cabinet. Bryant verified that the cash was on hand and assumed that Mackenzie had shown him all of the money in the investigative fund. But 2 days later, as he continued his audit, Bryant found something odd.
Discovered what we at the police department and city government refers to as Form 121. It's something of a requisition request form, which indicated an additional $10,000 had been requested by Assistant Chief Mackenzie for the investigative fund account.
More than a month earlier, well before the audit began, Mackenzie had apparently cashed a check for $10,000. But this transaction had never been recorded in the fund ledger.
Were you aware of the existence of this check prior to June 12, 1991?
No, sir, I was not.
Were they reflected in any way in the ledger books?
No, sir.
The day after he discovered the unrecorded check, Calvin Bryant went back to Mackenzie's office to look for the extra $10,000, but Mackenzie began to stall. He accused Bryant of being part of a conspiracy to frame him. Before he would open his safe, Mackenzie insisted on using the phone. As Bryant sat and waited, Mackenzie made 2 phone calls. The first one was short. The next one was to someone named Michael.
He held a conversation. At one point, he said to this person or into the phone, he's here now. Alluded to having talked to Michael about, since I was the only person there, I assumed he was talking about me.
But there really was no Michael. Mackenzie was actually speaking for 2 or 3 minutes to a recording that said he had reached a disconnected number. The other call was fake, too. The prosecution claims that McKenzie was trying to scare off Sergeant Bryant, but Bryant didn't budge. When the calls ended, Bryant insisted on seeing the money in McKenzie's safe. He found that $7,500 was missing. This is in addition to the $10,000 that was already gone.
I said to him that we have a problem here, Chief. The money is short.
What did he say to you?
His response at that time was, what? I guess that is a problem. And he said nothing else.
The state's case against Johnny McKenzie is based on circumstantial evidence, which is very common in a fraud trial.
Circumstantial evidence is all evidence other than direct evidence. It's evidence such as documents and witness testimony, which tends to prove a fact indirectly. The important thing about circumstantial evidence is that it has to be well prepared, well organized, and legally it has to exclude all inferences other than guilt.
According to the prosecution, there are 3 indirect indications that McKenzie may be guilty. First, a total of $17,500 is missing. Second, McKenzie cashed a $10,000 check to replenish the investigative fund, but never recorded the money in the fund ledger. Third, when Bryant asked to see all the money in his safe, McKenzie made fake phone calls, allegedly to intimidate him. None of this directly proves that McKenzie took the money, but under the circumstances, the jury might conclude that he did. As opposed to circumstantial evidence, direct evidence proves a fact without inference or presumption. If someone had seen McKenzie steal the money, for instance, this would be direct evidence. Most fraud trials, though, are based on circumstantial evidence. Sergeant Bryant's testimony shows the importance of direct testimony in fraud trials. This is where the case against the fraudster is spelled out before the jury. Before going into a courtroom to testify, keep in mind the following tips. Be prepared. Preparation means not only reviewing the facts of the case, but also working with the lawyer on the presentation of those facts. During his direct testimony, Bryant and the prosecutor often misunderstood each other. This disturbed the flow of testimony and made it harder for the jury to follow the story.
Had he opened the safe at this point?
No, he had not.
Had you asked him to do at this point?
At that point, I really didn't get an opportunity to ask him to do, I guess, anything specifically because of the disruption.
What did you ask him? Okay, what did you do next?
Fraud cases like baseball games or football games are won or lost before the first witness is called. It's all preparation.
Just the facts. Witnesses should limit their testimony to their first-hand perceptions, what they saw or heard. They're not allowed to tell the jury what conclusions they drew from their perceptions. Sergeant Bryant often lapsed into conclusions during his testimony.
As I spoke to him about the $10,000 flash bank, I got the impression from his...
No, I object. Object on any impression the witness got.
I sustain the objection to impressions.
It appears that McKenzie may have acted in a way which was incriminating. Calvin would avoid describing the actual words and behavior of the defendant and instead would characterize it as being nervous. Well, that actually hurt the prosecution's case. The jurors are far more interested in what McKenzie actually said and how he actually behaved.
Speak in narrative form. Approach your testimony like you're telling the jury a story. Use graphs and exhibits. In many fraud cases, it can be very confusing trying to follow the money trail. Exhibits help the jury maintain an interest in the case and make it easier to follow the evidence.
One of the things that the prosecutor fears in a fraud trial is that the juror loses interest. If the juror loses interest, they stop following the evidence. If they stop following the evidence, they go back and deliberate and can't recall the evidence, and of course then they can't comply with the standards that they find the defendant guilty.
Finally, speak plainly and directly. The jury may become confused by professional jargon. Explain things to them in a way they can understand. After direct examination, the opposing counsel gets an opportunity to question the witness. This is known as cross-examination. The goal of the lawyer on cross is to discredit the witness's testimony. Perhaps the biggest difference between direct and cross-examination is that on cross, the lawyer is allowed to ask leading questions. A leading question is one that suggests the answer the attorney desires. Court TV expert Meg Alverson explains the need for leading questions on cross.
Yes, in fact, that's what a good cross-examination is based on, leading questions, in order to try to take control of a witness who is theoretically hostile to you or hostile to your client's position, and by using leading questions, elicit answers that you want or may not otherwise get from a hostile witness.
A skillful cross-examiner will also limit questions to matters where the witness will be forced to give an answer that helps the cross-examiner's case.
Cross-examination is often a sham. The cross-examiner has seen the prior deposition testimony of the witness or the prior police statements of the witness. So the skillful cross-examiner limits his questions to those areas in which he knows the answer, and he knows the answer is helpful.
It would be helpful to the defense in this case to allege that McKenzie never received the money in the first place. In fact, the report that Calvin Bryant made at the time of the audit said McKenzie did not even appear to know what the flash roll was.
You wrote that in your report, didn't you? He didn't appear to be familiar with it.
He didn't acknowledge.
He didn't appear to be familiar with it, correct?
The report supports McKenzie's claim that he never had the flash roll, but Bryant doesn't want to give in.
Well, the problem I have is you characterize things as though they were genuine. I don't necessarily agree with that
Your Honor, I'm
characterization.
going to ask that the jury be withdrawn.
All right.
When the jury is withdrawn, it's usually because the lawyers and judge need to discuss something that the jurors should not hear. In this case, Bailey is upset about what he feels are non-responsive answers from Sergeant Bryant. After the jury is removed, he will state his grievance.
He did not give a responsive answer. I asked him whether or not that's what he wrote in his report. He said, well, the problem is you're characterizing it as if it were true, to give the jury the impression that he disbelieved it right from the outset. One of the strongest points in favor of this defendant's innocence was contrived on the spot, and he knew it. And that is absolutely false.
The jury is not withdrawn every time a lawyer objects to a witness's testimony, but in this case, Bailey was agitated. His comments about Bryant may therefore have been prejudicial to the jurors. When the matter is resolved, the jury returns to the courtroom and testimony resumes. The defense claims that the person who really stole the flash roll was Rick Bradshaw. He was the assistant chief who headed the investigative division before McKenzie took over.
He told me that the assistant chiefs were going to rotate positions and I was going down to uniform services. Yes, sir.
Bradshaw testified on direct that he turned over the flash roll to the defendant when they rotated positions. But McKenzie said he didn't even know the flash roll existed. He said Bradshaw gave him the general funds but never gave him the flash roll. As proof of this, Bailey points out that McKenzie never signed for the flash roll when he took over the investigative fund. It was the only time in department history that the recipient did not sign for it. If the transfer really took place, Bailey wants to know why Bradshaw didn't have McKenzie sign to verify it.
Well, why didn't you require that, Mr. Bradshaw, to relieve yourself of responsibility for this money, which was still under your control?
The state says McKenzie was not asked to sign for the money because the city treasurer was present to verify the transfer.
I didn't think it was necessary to relieve myself of that, since the person from finance who was delegated to come over there and count the money had indicated such that she counted it, and it was also verified by her, and he was standing right there with me.
In addition to framing McKenzie for the theft of the flash roll, the defense claims that Rick Bradshaw also took the $7,500 from McKenzie's safe. The question is, did Bradshaw have the combination? Bailey will use the testimony in Bradshaw's pretrial deposition to try to prove that he did. Michael Lawrence explains what a deposition is.
A deposition is a questioning session with a witness. It's like testimony in court, but it's outside of court and done in the lawyer's offices or the offices of the witness.
Depositions allow a lawyer to find out prior to trial how the opposition's witnesses will testify. If the witness's trial testimony conflicts with the deposition, the attorney can use this to discredit the witness's credibility. This is known as impeaching on a prior inconsistent statement.
Can you tell me the first page in that deposition on which you find any reference to the combination to the safe?
Page 30.
And then I give to Johnny the combination to the safe, which is kind of a yellow-orange piece of paper that has the combination on it. Am I reading correctly?
Yes, sir, you are.
Okay. Now, there is nothing in your answer that distinguishes the combination from the safe, old or new. Am I correct?
Only in my mind.
In your mind?
Yes, sir.
Bailey is trying to plant doubt in the minds of the jurors. Why did Bradshaw not distinguish between the old and new combinations in his deposition? Could it be that he really did have the combination to McKenzie's safe? The jury will decide. After cross-examination, the attorney who called the witness has the option of going into redirect testimony. The purpose of redirect is to try to repair any damage done to the case during cross-examination. Prosecutor Levine wants to clear up why McKenzie was not asked to sign when he received the flash roll.
If Mr. Bailey asked you, why didn't you have Mr. McKenzie sign, could you have ordered him to sign the ledger book?
No, sir.
Why?
He's the same rank that I am, and to be honest with you, I wasn't going to order him to sign anything, period. The purpose of the woman being there was to verify the money, which she did in front of both of us, signed the fact that it was there, and that was good enough for me.
After redirect, the defense has the option of recrossing the witness. After Bradshaw's testimony, the defense makes what is known as an offer of proof, also sometimes referred to as a proffer of evidence. During an offer of proof, the jury is removed.
A proffer is a session in which the lawyer places on the record the evidence which he wishes to elicit from the witness. And the judge can then determine whether he will let that evidence come before the jury or keep it out.
Is this? Do you understand that it is the defense point of view that if Johnny didn't take the money, the fellow who most likely could have taken it was Rick Bradshaw? Do you understand?
Yeah, I got the gist of that.
Okay.
The jury doesn't know that McKenzie passed a polygraph test about the theft, and the judge has excluded questions about whether Bradshaw would be willing to take one himself. Nonetheless, Bailey thinks the jury should be allowed to hear Bradshaw's testimony on this issue, and if the defense loses, he could appeal the case on that point. But in order for the appellate court to know exactly what was excluded, the evidence must be put into the record. This is known as preserving the error. So after the jury has left the courtroom, Bailey is allowed to question Bradshaw while the court reporter transcribes the testimony.
Mr. Bradshaw, did you take the money?
Absolutely, unequivocally, no.
Then I assume you would be willing to submit to a similar examination. Am I correct?
If that's what the investigator that investigates his case wants me to do, I don't have any problem with it.
No?
We now move to the testimony of Luann Halverson, the city treasurer. She counted the money in the investigative fund on the morning that it was transferred from Rick Bradshaw to Johnny McKenzie. Notice how Halverson appears to enter from outside the courtroom. This is probably because one of the attorneys has invoked the rule.
The rule means that prospective witnesses in the trial can be excluded while other witnesses are testifying. Usually one party has to ask the judge to invoke the rule. If a party does not do that, then the witnesses are allowed to attend.
There are some exceptions to the rule. Most notably, expert witnesses can attend the entire trial. In criminal cases, the police investigator is also usually allowed to remain in the courtroom.
Please state your name.
Luann Halverson von Seidler.
The state says Ms. Halverson witnessed the transfer of the flash roll from Bradshaw to McKenzie. Halverson is asked what she remembers about that day.
Assistant Chief Bradshaw was in the room, and a third individual was in the room.
Now, can you identify that third person?
No.
Do you know there was a third person in there?
Yes.
Court TV expert Trevor Gurrell comments on Halverson's inability to identify the defendant.
She's unable to identify that third party who's in the room. And it's a little curious, as we were saying a while ago, because if this were the third party were in fact Mackenzie, since he's the only black high-ranking police official in that department, and also considering his size, I would think she would readily recognize him to be who he was. But as she's saying now, well, I don't know who that other party was, so that seems a little strange.
Why could you not identify that third person?
I had never seen that person before February 8th, nor had I seen them after February 8th. And I couldn't pick them up out of a lineup or recognize them from a photograph, so I didn't think it would be fair to say that I believe so-and-so was in the room. I just know there was a third person in the room.
The trial now turns to the cross-examination of Rick Caplano, an agent for the Florida Bureau of Law Enforcement, brought in by the police to help in the case. Agent Caplano checked to see if Mackenzie had made any large cash purchases while he was in control of the investigative fund, and Bailey wants to know the results.
What's the result of that inquiry?
Which specific inquiry, Mr. Bailey?
The inquiry you made to see whether or not Chief Mackenzie had been handling or using, in the presence of witnesses, large amounts of cash outside his police duties.
I found no specific evidence of that.
What do you mean specific? You found no evidence, period, correct?
In most cases of employee fraud, a net worth investigation will turn up illicit income in large amounts. However, in this case, if Mackenzie stole money from the fund, Agent Caplano was unable to find out how he spent it.
May we approach him? Sure.
If you've ever watched a trial, you probably noticed that from time to time the lawyers huddled around the bench whispering to the judge. This is known as a sidebar conference. The lawyers go to sidebar when they need to discuss something that the jury is not allowed to hear. Notice that the court reporter transcribes the discussion so that it will be preserved on the record. Cross-examination can be difficult. Before testifying on cross, keep in mind some of the following tips. Don't expound. Answer the question, then stop. Watch how Agent Caplano gets himself in trouble on a question about Rick Bradshaw's access to the defendant's safe.
He told you he did. He could have gotten back in there after the money was counted by Luann Harrelson. He told you that, didn't he?
Are you talking about this 20 minutes or a half hour before the locksmith arrived? Is that...
Oh, did he tell you what time the locksmith arrived? Bradshaw? Ah. Tell us when Bradshaw told you the locksmith arrived.
Bradshaw has already claimed that he never saw the locksmith on that day. Caplano has inadvertently given Bailey an opening to assert that Bradshaw was lying. On cross-examination, you should avoid extraneous comments. If a point needs to be clarified, your attorney can do so on redirect. Control the pace. It's easy to become nervous or flustered on cross-examination. Take the time to think through the question before you answer it, and don't be afraid to ask the attorney to repeat a question. Examine documents before answering questions about them. Don't give testimony unless you know for sure what you're talking about. Don't rely on your memory of the contents of important documents. Be alert. If your attorney is making objections while the other lawyer cross-examines you, it may be because he sees a problem coming. This should tip you off to be careful with your answers. Don't be argumentative. There's a fine line between standing up to the attorney and being antagonistic toward him.
It's usually a mistake to try to match sarcasms, exchange sarcasm, or match wits with a defense attorney. The biggest problem is the jury doesn't like it. The jury perceives that the witness is not performing his or her role, which is not to be a wise guy, but just to answer questions so the jury can have something to base the case on.
Don't guess or speculate. If you don't know the answer, simply say, "I don't know." Be courteous and respectful. You will appear more objective and professional, and you'll make a better impression on the jury. Anytime you're testifying, the most important thing is to be prepared. The sole expert witness in the Mackenzie case is James Walls, a handwriting analyst. Experts like Walls testify when scientific, technical, or other specialized knowledge will assist the jury.
I started my training as a document examiner in 1970 when I was a member of the Pennsylvania State Police.
Before an expert can testify, the attorney must lay a foundation by demonstrating that the witness is qualified to give an expert opinion on the subject. A witness's expertise can be established by showing formal education, advanced study, and or experience.
The witness has to demonstrate to the judge through the testimony that the witness has some experience, some education, some other background that allows that witness to be more credible or more experienced, able to give more technical information in a specialized field of knowledge.
Are you certified in the field of forensic document examination?
Yes, I'm certified by our department. I've also obtained a diplomate status with the American Board of Forensic Document Examiners, who also every 5 years review your qualifications.
If the judge feels the witness is qualified, then the witness will be allowed to testify as an expert.
Your Honor, at this time we'll tender Mr. Walls as an expert in the field.
Objection. Very well.
Normally, witnesses are not allowed to offer hearsay testimony or state their opinions about a case, but experts are the exception. In fact, experts are hired specifically to give their opinions. In this case, Mr. Walls testifies that Johnny McKenzie endorsed the $10,000 check missing from the ledger.
As a result of my examination and comparison, I reached the opinion that the author of the known writing, purported to be that of Johnny B. McKenzie, is the same person who executed the signature endorsement on the back of State's Exhibit 10.
Expert testimony is often crucial in a fraud trial. In complicated cases, the jury relies on experts to sort out and explain complex evidence. If you testify as an expert, keep in mind the following tips. Don't exaggerate.
Well, expert witnesses sometimes overreach in their opinions. They are hired by one side, obviously. They identify with that side. They want to do as good a job as possible for that side, and so they may tend to overreach. And a skillful cross-examiner can then undercut them and show that they have exaggerated a position or they have ignored other authorities or contrary evidence.
Speak plainly. Walls avoids technical jargon when he speaks to the jury. He explains the theory of handwriting identification in a way that the jury can understand.
When a person first learns to write, you have to concentrate on the movement of the pen to form each letter. Gradually, through a constant repetition of this act, you develop your own personal writing habits. But if you encounter two bodies of writing that contain a series of significant similarities with no differences that go beyond the normal range of variation that everyone employs in their writing, you can safely say that they are both executed by the same person.
Don't be argumentative. This takes away from the force of your testimony and may make you appear to be biased. If you don't know something, admit it. Trying to explain something you don't understand can make you look foolish in the eyes of the jury. Be visual. Instead of merely telling the jury what his opinion is, Walls shows them too. This makes it easier for the jury.
There is a capital J, an O, an H abbreviation, a lack of the double N combination, and then into a speed type Y with the downward movement and a lack of a connecting or oval stroke to the top of the writing line. I found this to be similar in the known signatures.
Don't expound. Examine documents under discussion. Be prepared. As with all witnesses, the more prepared you are, the more persuasive your testimony will be. In presenting its case, the defense decides to call Johnny McKenzie himself as a witness. According to the Fifth Amendment, criminal defendants cannot be compelled to testify against themselves. But in a civil case, there's no such protection. Allowing a criminal defendant to testify can be risky.
You are Johnny McKenzie, the defendant in this case?
Yes, I am.
How old are you, Johnny?
44.
McKenzie has claimed that he's the victim of a conspiracy. But to make this argument believable, he needs to explain why anyone would want to frame him. McKenzie's theory? That he had uncovered high-level police misdeeds in the auctioning of surplus city equipment.
There were several employees, city employees, that were, if you had a bid item for instance, $120. You had several employees who were the guy who was in charge of supervising this auction would set aside certain items for the police department members, and that item probably would be for maybe a quarter of that cost. For instance, he would pay $25 for a $125 item.
McKenzie said he saw the conspirators huddled in Calvin Bryant's office the day before Bryant's second audit.
What happened to the conversation that was going as you appeared going by the door?
The conversation died down, or the talk sort of, they stopped talking. There were some signals that I was in the area or something, but the talk died down. Calvin alluded them the fact that I was in the hall, and the conversation ceased.
According to the defense, this tipped off McKenzie that he was being set up. They say this explains why he made bogus phone calls trying to intimidate Sergeant Bryant. As for the $10,000 that McKenzie failed to record in the ledger, he says this was simply an oversight.
Did you at any time make a note to yourself about the need to record the cash check?
Yes, sir.
The defense has produced a calendar in which McKenzie recorded his personal appointments. The calendar contains a supposed reminder to enter the $10,000 in the ledger. McKenzie says this is proof he never intended to steal the funds.
The top of the page is notes and memos made in April. Don't forget $10,000 fund to be entered in book.
Okay. Is that your handwriting?
Yes, it is.
If McKenzie really had done nothing wrong, why did he make the fake phone calls? McKenzie says he was bluffing Calvin Bryant in order to smoke out the conspirators.
Remember, I just wanted to find out if indeed there was something going on. I figured if I was making an effort to make some calls and he knew I was serious, that I felt that he would do the next best thing, and that would be to contact those individuals who I felt in my mind that was responsible for him being over there in the first place.
Prosecutor Levine now gets his chance to question McKenzie. Although the defendant in a criminal trial cannot be compelled to testify, once he does, he must submit to cross-examination. The first thing Levine attacks is McKenzie's conspiracy theory. If McKenzie knew he was being set up as he testified, then why didn't he tell the chief of police on the day he was suspended?
You never mentioned a conspiracy to Chief Riggs on June 13th at 4:30, right?
We talked about some concerns I had.
You never used the word conspiracy. Is
No,
that
I did
true?
not. That is true.
You never said that you were being set up.
Note the way Levine is using leading questions to force McKenzie into yes or no answers. This allows the prosecutor to make his points and control the flow of the testimony.
The money was missing, and they were accusing you of $10,000 more being gone from flash rolls, but you say you never got, right?
That is correct.
And all you can say to the chief was that Cal Bryant's unethical, right?
Next, Levine turns to the calendar in which McKenzie supposedly made the note to record the $10,000 check. The problem with the calendar is that McKenzie had it in his possession after Sergeant Bryant's audit. He could have made the note at any time. McKenzie had 2 other appointment books which were confiscated when he was suspended, and these contain no mention of the check.
In this calendar, there is no reference whatsoever to a $10,000 check. True?
That is correct.
In this calendar that you held from June 13th, 1991 until April 92, there is a reference, correct?
Yes, there is.
Levine's cross-examination finally settles on the fake phone calls McKenzie made in front of Calvin Bryant, especially the 2 or 3 minute conversation with the fictitious Michael. McKenzie has still not offered a convincing explanation, and Levine wants to emphasize that point to the jury.
Was it at least 2 to 3 minutes?
Possibly.
And you were once again having conversations with nobody, correct?
That is correct.
You were talking to the air, correct?
That is correct.
And you heard on the other line that this line is out of service, correct?
Possibly, yes.
Your purpose to make that call was to get Calvin Bryant to back off, correct?
My purpose was to see who would be the next contact person he would get to come in, since I was making those calls. That was my purpose.
After McKenzie's testimony is finished, The defense rests. In closing arguments, each side sums up the evidence for the jury, pulls together all the loose ends, and explains why the jury should find for its side.
Principal focus of the argument is to relate the evidence that you have given during the trial to the specific questions that are going to be answered. In considering this issue of fraud, remember witness A's testimony about the circumstances of this. Focusing on final argument, the attention to the evidence that relates to the specific questions that they're going to be answered.
In closing arguments, the party with the burden of proof, in this case the prosecution, goes first. Levine will rebuild the state's case for the jury block by block. First, he attacks the conspiracy theory.
To believe the defendant would to believe that he was not only a victim of a conspiracy once, he was a victim of a conspiracy twice. That not only was he not given the $10,000 on February 8th, but that somebody surreptitiously between this date and this date went into his office and took $7,499.
Then he reminds the jury that McKenzie never said anything about the $10,000 he failed to record in the ledger until Sergeant Bryant found the missing check.
Did the defendant say at the June 6th meeting that he had a May 6th check of $10,000? No, he did not. Did he say it on June 10th? No, he did not. Did he say it on June 13th? No, he did not.
He also points out once again the curious phone calls.
The two phone calls that were, one, admittedly by the defendant's own words, bogus. Those two phone calls, he told you that he was on the phone pretending to throw Calvin off. Ask yourself, is the defendant acting like an innocent man or a guilty man?
When the prosecution is finished, it's the defense's turn. Rather than meet the state's case head on, Bailey chooses to focus on the alleged conspiracy.
But in January of 1991, the West Palm Beach Police Department, at its highest levels, had no more fervent hope than that the Jewett case would go away and his asking pressing questions of anyone in the department, threatening the good old boy syndrome that did the auctions, rigged auctions years before.
Bailey will remind the jurors that McKenzie never signed for the $10,000 flash roll.
For the first time in the history of the West Palm Beach Police Department, it is decided by someone that the recipient supposedly to be charged with the receipt of money will not be given the opportunity to acknowledge it. That decision was made.
In some jurisdictions, closing arguments end when the defense is finished. In others, the prosecution is allowed the final word since it has the burden of proof.
A very capable and well-prepared prosecutor on rebuttal can be devastating to a defendant that's guilty, because probably the most effective part of a closing argument is to take the defense's argument and then take it apart block by block by block. And if you're able to do that, then it's devastating to the defendant. And one of the things about a skillful fraud examiner or a skillful lawyer preparing a case is that the fraud examiner and the lawyer is looking from the beginning of the case not only to the evidence that might be used to prove the elements of the case, but is trying to anticipate the defenses that might be raised and doing the work to rebut those defenses.
After closing arguments, the case goes to the jury. The judge presents a charge to the jury at this stage. The charge is a list of questions that tell the jury exactly what issues it must decide.
The jury charge is a very important document because these are the questions that are going to be asked to the jury. Their answers will determine the judgment that's going to be entered. Fraud. Do you find from a preponderance of evidence that one of the parties has committed fraud? Conversion. Do you think that one of the parties has converted the funds?
The judge reads the charge to the jury before they deliberate. The jury will also take a copy of the charge with them to the jury room.
The state must prove the following two elements beyond a reasonable doubt. Number one, that Mr. Johnny McKenzie knowingly and unlawfully obtained the property alleged to be that of the city of West Palm Beach. Number 2, that he did so with the intent to either temporarily or permanently deprive the city of West Palm Beach of its right to the property.
In a criminal case, the state must always prove the defendant's guilt beyond a reasonable doubt. However, if this were a civil trial, the burden would be much lower.
The primary differences between civil fraud and criminal fraud have to do with the burden of proof. In a criminal case, the prosecution has the burden to prove it beyond a reasonable doubt. And in a civil case, it's a preponderance of the evidence.
The preponderance of evidence standard is often referred to as the 51% rule because in order for the civil plaintiff to win, the jury only has to be more than 50% sure that the defendant committed the acts in question. After the charge is read, the jury retires to reach its verdict. A bailiff stands watch to make sure no one enters or leaves the jury room. A foreman is elected from among the jurors. During deliberation, the jury can request to see evidence or exhibits again, or to have the instructions in the charge clarified. The jury can also request to have the testimony reread. That was the situation in the McKenzie trial.
This is the direct examination of Sergeant Bryant by Mr. Levine. Question: did there come a time when you came back to the defendant? Answer: yes. Following that initial date, June 6th, my next visit with him would have been June 10th, the following Monday.
Eventually, a verdict is reached. At this point, the jury re-enters the courtroom and the written verdict is presented to the court.
All right, Mr. Mixon, has the jury reached its verdicts?
Yes, sir. Yes.
Please hand them to the bailiff.
We, the jury, find as follows.
Count 1 is for the theft of $10,000, either the flash roll or the unrecorded check.
As to count 1, we find the defendant not guilty.
Count 2 is for the theft of $7,500, the money missing from McKenzie's safe.
As to count 2, we find the defendant guilty of grand theft as charged in the information.
Count 3 is for official misconduct, failure to record the $10,000 check in the ledger.
As to count 3, we find the defendant guilty of official misconduct as charged in the information.
Either party now has the right to have the jury polled. It's very rare for one of the jurors to recant at this point, but if one does, the jury will go back into deliberation.
Juror number 1, Michael Weeks, was a verdict as regular verdicts. Juror number 2, Joanne Manslow, was a verdict as regular verdicts. Juror number 3, Joyce Wilson, was a verdict as regular verdicts.
In criminal trials such as the one we've just seen, the jury's decision must be unanimous. That may or may not be the same in civil trials. Some jurisdictions only require a vote of 10 to 2 or 5 to 1, depending on the number of jurors. If the jury cannot get the necessary votes for a verdict, the result is a hung jury.
Now, there's a famous saying in the law that everybody's entitled to a fair trial, but not a perfect trial. There is no such thing as a perfect trial. And so there are some compromises in the actual trial of cases where judges do the best they can, but the case has to come to an end at some point.
The jury's verdict declares the winner of the case, but the verdict is not official until the judge enters the judgment.
Many times you have weeks or even months that pass between the time that the verdict is actually brought in by the jury and the time that the judge actually enters judgment.
The judge has 3 options after the verdict is returned.
The judge can enter a judgment that incorporates all the findings. The judge can, in certain circumstances, determine that while he can't change the verdict, he or she did not believe that the trial went according to the rules in some manner, and simply grant a motion for a new trial and start all over again. Or the judge can enter a judgment, what's called a judgment notwithstanding the verdict. And that judgment is that regardless of the answers that the jury gave, some other judgment is appropriate because of the application of law.
The trial is over after the judgment is entered, unless appeals are filed alleging that procedural errors or misinterpretations of the law were made. If these appeals are successful, the parties may have to go back and retry the case from the start. In the American system, the whole process can take years to complete. Here's what we've learned from this video presentation. All trials consist of 7 steps, commencing with jury selection and concluding with the final judgment. Frauds can be criminal in nature, or they can be civil, or both. The main difference in criminal and civil fraud is the amount of proof required. Witnesses in trials should prepare thoroughly. They should listen carefully before answering questions, and only then answer what is asked. Expert witnesses, unlike regular witnesses, can be qualified to testify about their opinions. Any opinion rendered should be adequately substantiated. We've also learned the difference between direct and circumstantial evidence, and that most fraud cases are proved through circumstantial evidence. Written instructions to the jury are particularly important to the final outcome of the case. Verdicts in criminal cases must be unanimous, but in civil cases that is not always necessary. Finally, we've learned that fraud trials, regardless of how much money involved, can be very serious matters that affect people's lives dramatically. Mackenzie was convicted, but he never spent a day in jail. Instead, he got probation. Still, he paid a big price. Johnny Mackenzie threw away a promising police career for a measly $18,000. But you know the saying, the bigger they are, the harder they fall. For the Association of Certified Fraud Examiners, I'm Joseph Wells.